Well, good morning. It is Wednesday, March the 17th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio,
Here.
Farmer,
Here.
Griffey, Hardaway, Howell, Lamberth, Moody, Russell, Sexton, Chairman Doggett.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam. Any personal orders before we begin? Chairman Curcio.
Thank you, Mr. Chairman. I just wanted to welcome Representative Beck's jacket to committee today.
Yes, definitely. Yes.
Thank you, Representative Beck.
That's Obeck, Mr. Chairman, Obeck.
Representative Obeck. Leader Lamberth.
The sister jacket to that is worn by Dr. Kumar today, and we would welcome him as well. So thank you, Dr. Kumar.
Any other items before we proceed? Members, we're going to do some work today. We're going to take up a few bills this morning, then we're going to dedicate some other time to, we have several here to testify on a couple pieces of legislation. But we're going to go through the calendar and look at a few things first here. If you'll notice, if you'll go with me to item number 8, House Bill 109 by Chairman Hulsey. That'll be rolled 2 weeks without objection. House Bill, item number 10, House Bill 957 by Chairman Littleton. That will be taken off notice. Item 13, House Bill 924 by Vice Chairman Wright. Without objection, will be rolled 2 weeks. Item 15, House Bill 733 by Representative Smith. Without objection, is rolled 1 week. Item number 21, House Bill 1479 by Vice Chairman Parkinson is off notice. Item 22, 1480 by Vice Chairman Parkinson is rolled 1 week. Item 26, 592 by Representative Clemens, rolled 1 week. I'm sorry, Representative. That was item number 26, 592. We're on item 27, House Bill 600, Representative Hodges, rolled 2 weeks. Item 42, Vice Chairman Sexton, House Bill 1313 is off notice. And that is all we've got to take care of there. So let's dive right into our calendar. Item number 1, House Bill 1074 by Chairman Kumar.
Motion. Second.
You have a motion and a second. There's an amendment number 005080. Is that an amendment you wish to consider?
Yes, Mr. Chairman.
Okay, we get a motion and a second on that amendment. All right, properly. Forrest, go ahead and introduce your amendment, please.
Thank you. The amendment adds the healthcare workers to this bill, so it would maybe, if you please, add the amendment to the bill, and then I can explain the amended bill.
Question's been called on the amendment. Any objection? Seeing none, we're now voting to adopt amendment code 005080. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. It is adopted. We're on House Bill 1074 as amended.
Thank you, Mr. Chairman. Our country and indeed the world has been through a great deal over the last year with the pandemic. The healthcare work is as such stressful because we come across tragedies and difficult times. And healthcare workers are concerned about their safety and the safety of their families. At the same time, the citizens that they serve are also concerned about the same things and are under equal stress. Considering stress among healthcare workers and the citizens that they serve, there is frequent room for argument leading to altercation and other problems. This bill increases the penalties for assault on a healthcare worker, on first responders. In addition, it adds the healthcare workers also to that group.
Thank you very much. You've heard the explanation. Any questions for our sponsor, Representative Beck?
Thank you, Mr. Chairman. And is this just when they're on duty?
Yes, that is true.
And what are you proposing? I'm sorry, I didn't get a chance to read it. What are you proposing that raises it from and to?
It raises it from Class A misdemeanor to Class E felony.
And lastly, I want to applaud your tailor. Great choice this morning.
Thank you.
Representative Hardaway.
Thank you, Mr. Chairman, and good morning to you, sir.
Good morning.
Your outfit makes my little green and my tie look woefully inadequate. When the conduct of the offender, are there allowances built into current statute or in your bill that will allow for the effect of drugs or psychological matters, incompetence?
Those are very reasonable ideas that you have, but I think that is up to the courts to decide any extenuating circumstances under which the problems occurred.
But it is your intent that those be considered?
Certainly.
Okay.
That's
Thank you.
justice.
Thank you, sir.
Sure.
And we're looking for justice.
Thank you very
Mr.
much.
Chairman.
Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting, sending House Bill 1074 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. The bill moves on. Thank you.
Thank you, Mr. Chairman and committee.
Item number 2, members, House Bill 718 by Chairman Kiesling. We have a motion and a second. You are recognized.
Okay, I'm on, right? Thank you, Mr. Chairman and members. And if I may take personal privilege, I too would like to recognize the our host legislators' sport coat this morning, the bright green. Representative Beck, you fit right in this morning. And should, following my presentation, should there be any questions to me, the sponsor, you may address me as O'Kelly Kiesling, if you would like to do that. With that, Mr. Chairman and members, I would like to introduce to you House Bill 718, which we call the Safe Seniors Act of 21. It's not my first time here, is it, when we talk about our senior citizens? But over the last 4 years, you have overhauled, together we have overhauled, I should say, Tennessee's law. And is there something that I've said, Mr. Chairman, do you think?
I believe that's your curtain call there. That's your cue.
Or could it be something that I addressed to Representative Beck over there? Someone has taken offense here, haven't they? So. Oh, okay.
Mr. Chairman.
Would you allow me to begin again, sir?
If you'd like to continue on, please do.
Okay. Well, over the last 4 years, we have overhauled Tennessee's law to help protect our vulnerable and adult population. Over those years, we've identified some places that need to be cleaned up, but also some that's going to require a few additional changes. I'd like to highlight three quickly. One is making the process a little easier to take an adult, a elderly adult's deposition. Two, making certain that our APS or Adult Protective Services can make disclosures to our prosecutors. And finally, three, allowing aggravated elderly abuse to be considered an offense that would follow up to be a felony murder if the elderly adult dies. Altogether, we believe these changes will assist law enforcement and prosecutors in taking dangerous individuals who abuse our elderly and vulnerable adults off the streets, and assist judges in making sure that those sentences available to them upon conviction reflect the severity of their crime. Now, we could, I could spend, Mr. Chairman, there's 16 sections in the code, members, that this affects. And, I know that we're time sensitive today because of the presentation. We are fortunate and thankful that we do have both Guy Jones and Zoe Sams, who's director and deputy director here with our Tennessee District Attorneys General's Conference. But also we have requested to your office, Mr. Chairman, the possibility of a brief testimony by by General Matthew Stowe of the 24th Judicial, if you deem that you or the members deem that necessary. With that, I'll pause and.
Well, thank you, Chairman, and very appreciative of those that have come to want to testify. I think that we're in a very good position here to go ahead and move along with your legislation if you're okay with that.
Oh, absolutely. Thank you, sir.
So is there any objection to the question? Any questions for the sponsors? No? Representative Hardaway?
Thank you, Mr. Chairman. I was merely going to ask if, when the lights went out, if O'Kelly was going to call on his father, "Oh Lord."
It's a good question, but no, we're. Oh man.
All right, thank you. All right. Questions called. Any objections? Seeing none, we're now voting on sending House Bill 718 to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You go to full criminal. Thank you.
Well, thank you very much, Mr. Chairman and members.
Members, we are going to jump ahead here just a few places, if you will. Item number 5 on your calendar. Let's see if I can find it there. House Bill 976 by Chairman Williams. We have a motion and a second. There's an amendment. Motion properly before us, 004927. You wish to proceed with that amendment?
Yes, sir.
Okay, please do.
The amendment 4927 is the clarification amendment requested by leader in consultation with this substance. And so all it would do is just further clarify about this substance being a prescribed FDA-approved substance. With that, I'm happy to answer any questions.
Thank you, Leader Lambert.
Thank you, Chairman. Thank you for bringing this bill and this amendment. We talk about medical marijuana a lot out there, and there's an enormous number of snake oil salesmen and ne'er-do-wells that try to sell off a substance that in many cases won't help somebody for a particular illness. I mean, they try to make it like it's a cure-all. There are benefits from lots of different substances, lots of different plants and everything throughout this world, and cannabis has some medical benefits to it, and that's been proven. Your bill lets the doctors take over instead of the guys at the 7-Eleven trying to practice medicine. I mean, you can't go in somewhere without them trying to sell CBD oil or hemp oil, and, some would want them to be able to sell, marijuana at every local convenience store and claim that it's medicine. I don't know about you, but that's not where I go for medicine. I go to my doctor, I go to medical professionals, I go to a nurse practitioner or someone like that. This bill sets up true medical marijuana, where if it's FDA approved or if the feds will just get out of our way and stop putting it in a way that we could not discuss this at the state level, your bill makes it where our doctors, our patients, Tennesseans can get the help they need, but get it from a medical professional. So thanks for bringing the bill. We really appreciate it.
Questions been called on the amendment? No, that's fine. Okay. Question was called on the amendment. No objections. We will now vote to adopt amendment number 004927. All those in favor say aye. Those opposed, no. The ayes prevail. We adopt. We're now on House Bill 976 as amended.
Yes, Chairman and members, this bill as amended describes, as the leader did, but it simply exempts from the definition of marijuana the word cannabidiol as it relates to an FDA-approved medication. That being said, I'm happy to answer any questions you got.
Thank you, Representative Beck. You wish to speak?
Yes, thank you. So this would only apply to FDA-approved cannabis treatments, is that correct?
Yes.
So if someone is driving through Tennessee and is pulled over and they have a medication from another state that's not FDA approved, does this? Of course, we know that that's already not accepted in the state of Tennessee. Does this affect the criminality of that in any shape, form, or fashion?
This bill has nothing to do with this. This only removes from the definition of marijuana this one substance because it does have an FDA-approved substance as it relates, similar to the traits of marijuana, but it does treat spasticity in adults, and so it's in its third trial, and so that's what this bill does. It makes it legal to prescribe this in the state. This bill does not affect any other state's prescriptive authority or change the legality of any substance in our state other than this one.
Very good. Thank you for that explanation.
Mm-hmm. Thank you. Any other questions? Seeing none, any objection to the question? Seeing none, we're now voting on House Bill 976 as amended. To move on to full criminal, those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full.
Thank you, Chairman and members. I just wanted to say the reason why our two colleagues are wearing the green jackets today is because they are recreating the movie Twins with Arnold Schwarzenegger.
All right, members, let's move on to item number 7 on the calendar, House Bill 108 by Chairman Hulsey. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. Thank you, committee. In keeping with the holiday, I wanted to inform the committee I am half Scotch and half Irish, and all that means probably is half of me wants to get drunk and the other half don't want to pay for it. I just wanted you to know that. Mr. Chairman, this bill, the intent is to move voluntary manslaughter from a Class C felony to a Class B felony. And the reason for that is if I take a knife and display it and threaten you, that is aggravated assault, Class C felony, it's 3 to 6. If I take a gun and point it at you, but I don't shoot you and I threaten you with it, that is aggravated assault, a Class C felony, 3 to 6. If I intentionally or knowingly actually kill you in a state of passion provided by adequate provocation, the crime's voluntary manslaughter. That's a Class C, 3 to 6. Now, you exacerbate that with a jury when a jury's hearing cases of first or second degree murder and you reach a compromise verdict and they reduce it to voluntary manslaughter. And this family goes away after they understand that this guy sat in jail for a year and he got 1 for 1 or a day for day in the time he stood there. By the time he gets out of jail and goes to trial, he's eligible for parole on a 3 to 6 sentence for killing somebody. So the inequity of the law is probably something we should have fixed a long time ago, and that's what this bill does. It raises voluntary manslaughter from Class C to Class B felony.
Thank you for the explanation. Any questions for our sponsor? Seeing none, any objection to calling the question? Seeing none. We're now voting on sending House Bill 108 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We move on. Thank you. Let's skip down to item number 14. Item number 14, which would be House Bill 1211 by Vice Chairman Baum. Motion. Second. We have a motion and a second. You are recognized.
Thank you, Chairman. Folks are ordering merchandise online more and more today than ever before, and they don't like it when their packages arrive on their front porches and are stolen. About a third of Americans are reporting a package being stolen at least once. And this is legislation that would increase the penalty on theft of packages from a front porch. It wouldn't do it on first offense, but on second offense, the bill would mandate that the punishment is at least a Class E felony.
Thank you. Any questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 1211 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail.
Thank you all.
Thank you. Item number 16, House Bill 981 by Representative Gillespie. Motion. Second. Your motion is second. You're recognized, sir.
Thank you, Mr. Chairman. This is a bill that really addresses interstate shootings that we're having all across the state. Here in Davidson County, in Shelby County last year, we had 83 separate incidents of this, and what it seeks to address is it increases the penalty of the offense of reckless endangerment with a deadly weapon to a Class D felony if the offense occurs while road rage is being committed. And if you have any questions, I welcome them.
Thank you for that. Any questions for our sponsor? Representative Beck.
Thank you, Mr. Chairman. In this, sometimes a vehicle is considered an instrument of deadly force. Under reckless endangerment, would a vehicle, okay, because we're talking about road rage, et cetera, correct?
Yes, sir. And I can give that definition.
That'd be good.
Road rage is defined as aggressive behavior of a driver or drivers on a public road, which may include menacing gestures, yelling, honking, excessively, or throwing objects.
Okay. So under your bill, we're increasing reckless endangerment with a deadly weapon. Is the vehicle considered a deadly weapon?
Sorry, sir, with a firearm.
Oh, it's just with a firearm.
Yes, sir.
Very good. Thank you so much.
Thank you. Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 981 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Thank you.
Thank you.
Representative Hardaway, you recognize.
Thank you, Mr. Chairman. And I want to thank the sponsor on that bill. This is something that is of real urgency down in Shelby County, and we've grateful been able to work on it together, and I'm 100% behind it.
Thank you. Thank you. Members, we'll go to item number 9 on the calendar. House Bill 342 by Chairman Littleton. Motion. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman. This bill was brought to me by the TBI Human Trafficking Advisory Board, and it says if it is determined after a reasonable detention for an investigative purposes that a person suspected of or charged with violation of this section is under the age of 18 years, that person is immune from prosecution for prostitution as a juvenile or adult.
Thank you for that. Any questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 342 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on.
Thank you very much.
Members, we will journey back down to item number 3 on your calendar, House Bill 578 by Chairman Reagan. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman and committee. As I noted last time before you, this bill has been here last year and passed. Just a reminder of that, there were some members that had questions about it. I took it off notice and addressed those questions. I believe they've been adequately addressed. What this bill seeks to do is protect innocent minor children, that is, those citizens who legally lack the maturity to make irrevocable decisions, potentially damage their own health or well-being. Each of you should have received a copy of my talking points. It's not my intent to go over all of those again unless you have questions. I do want to emphasize a few things, though, and that is this bill is aimed at 2 different groups. One is pre-puberty, that is children who have not yet attained that status, and it's defined in the bill and in our code, and a group post-puberty. And the post-puberty group is also given an exception with the condition being approval by parents or guardians and a team of doctors. 2 doctors must recommend it, and a 3rd doctor who must be board certified as a child psychiatrist must also agree to it. I will point out that for the first group, that is the pre-puberty group, the side effects of giving puberty blockers and sex hormones are potentially very serious. Some of them not so serious in some cases, like severe joint pain or osteoporosis. However, some are more serious, like compromised immune systems and mental health issues. Our FDA has 24,000 reports of adverse reactions from this sex hormone therapy, and they were deemed serious. I would also emphasize that puberty is not a disease. It is a naturally occurring phenomena of the human race. The drugs that are used as puberty blockers were developed for other unrelated medical conditions. Originally, in 1989, Lupron was developed to treat prostate cancer in men and endometriosis in women. I will emphasize there is no FDA-approved drug or procedure that is in existence for specifically treating youth transgenderism. Drugs that are used in this capacity are deployed off-label. That is to say, physicians are prescribing it for something other than it was approved use. I will also point out that surgery, which is one of the things this bill seeks to limit, is permanent. We already have laws on the books that prevent permanent damage to minors, even with parental approval. 3913.110 is an example. That's the female genital mutilation restriction. That is restricted even with parental approval. 3913.607 is also a restriction even with parental approval. That one, by the way, is the peeping Tom law. In other words, a parent can't approve a minor being viewed without permission by someone else. That is a felony. The American College of Pediatricians has condemned hormone treatment and surgical operations on children with gender dysphoria as child abuse. As such, this bill seeks to punish it if it occurs intentionally. I would point out, by way of emphasis, that this bill does not prevent intervention for those children over the age of puberty and under the age of 18 with the conditions I have already specified. I would point out also, there's a quote very applicable to this. But before I get to that quote, another fact that's worth noting is that an overwhelming majority of people who undergo this transgenderism as young people or minors later regret it. There's some articles that have been in prominent press location on that. In short, it seems to defy common sense. The quote I'll give you was actually by Daniel Petruccelli in the O.J. Simpson trial, and he was quoting a 1933 Marx Brothers movie called Duck Soup. His quote was, who are you going to believe? Me or your lying eyes? The idea that we can defy reality by just saying we think this is the way it is or we feel this is the way it is an absurdity. And with that explanation, I stand ready to answer questions.
Thank you, sponsor. Any questions for our sponsor? Representative Hardaway.
Thank you, Mr. Chairman. I want to be clear, there are or are not new civil or criminal penalties associated with the legislation.
Yes, the bill contains a criminal penalty for doctors who knowingly perform this on children below the age of puberty. It also makes it a criminal, a civil offense that can be action brought under. And it also defines it as something that it can be brought before a health professional board for the health professional misconduct.
And that's with or without the parent's permission?
In the case of pre-puberty, there is no parental permission. This bill prohibits it, period. Post-puberty, the bill allows for parental permission, 2 doctors, and a third doctor who's a child psychiatrist to be involved in this. In that case, there is no penalty.
And can we just say unconditionally that there's never a case of pre-puberty where the drugs, which may result in the consequentially result in the same state of transgenderism, where that would not be a medical necessity? Or does your bill allow for those exceptions?
The bill allows for exceptions, and if you'll permit me, I'll quote it. A confirmed diagnosis of abnormal birth defect involving genitalia or gonads, genetic anomalies involving X or Y chromosomes, physical disease with life-threatening consequences absent such intervention, and an accident irreparably mutilating genitalia. So there are exceptions in the bill.
For pre-puberty?
The exception does not specify pre or post, so obviously it applies in both cases.
Okay, that's what I wanted to get clear. Thank you, sir. Thank you, Mr. Chairman.
Representative Beck.
Thank you, Mr. Chairman. To the sponsor, you know, I've read a lot about childhood suicides. And, you know, when I'm looking at this legislation, it makes me think about empathy, putting yourself in their place. Children these days have trouble seeing years, months, even days down the road sometimes. And if they feel that they are trapped in a situation, it often leads to suicide. I don't know why we would criminalize a doctor's medical opinion that a child would need the surgery in order to get them to live to see puberty, in order to get them to live to see majority. Can you speak to that, sir?
Well, I would address your question with another question, and that is, would we pass a law saying that bulimia and anorexia, if a doctor so prescribed a diet for these individuals to increase weight loss, would we view that as being helpful? I think not. The idea is that this condition is broadly classified as something called body dysmorphic disorder or somatic delusional disorder. The point I'm bringing up with those diagnoses is if someone commits suicide in the absence of intractable pain or some other life-threatening condition, we generally classify that as the ultimate mental illness. So are you suggesting with your question that we should treat mental illness with surgery? If so, I would point out that doctors tried to do that from the 1920s on with something called prefrontal lobotomies. They were attempting to treat mental illness with surgery. We have since recognized that doesn't work. Not only doesn't work, it was cruel. It crippled some of these people mentally. We do not need to allow this to continue in the absence of overwhelming evidence that it's necessary. Children under the age that is described to puberty frequently think they want to do a lot of things that time, experience, wisdom of advice from others change their minds. My son wanted to be a fireman. My daughter wanted to be a nurse. She grew up to be a teacher. My son grew up to join the Air Force and fly fighters. In neither case did their childhood desires continue on after they gained some experience. And I submit to you that this is a similar situation. In most of these cases, that the research we have, which is limited, I'll admit, but in most of these cases, the children who think they want to do this later change their mind, which is common in childhood.
Sir, maybe I misunderstood you, but I got the impression that you just made the insinuation that if someone feels trapped in their birth sex, that they're not supposed to be in that birth sex, that you referred to that as mental illness. Was that correct or incorrect?
I referred to that as body dysmorphic disorder or somatic delusional disorder, sir. Those are APA-defined definitions.
So, if I was, my point would be that I would want them to live to see puberty. I'd want them to live to see majority. And you mentioned dieting diseases or other diagnoses that you thought were poor medical opinions. Those can always be handled civilly. I don't understand why we would make a medical opinion criminality here. And
sir, the medical opinion is not criminality. It's the action from it. And I would again submit to you that doctors are human beings like all of us. They make mistakes like all of us. Furthermore, as I pointed out with the example I gave you of prefrontal lobotomies, some of those mistakes are accepted. I could go on. We could talk about, for example, bleeding. That was an accepted medical treatment up until the end of the 1800s. Today, it's not. So the idea that we can say a doctor says this is my opinion and we should treat that without common sense is something I object to.
I don't think we can go back to leeches as comparing apples and apples here. Today, we've seen that this being the feeling of distress, the feeling of anxiety, the feeling of not being able to go forward, being trapped in a different sex than what your birth sex was. Again, we'll have to agree to disagree because I believe that I want to see these young people develop, and I want to see these young people live, and I don't want them to feel that we are sitting here as legislators telling them what they should do with their bodies. Thank you very much.
Thank you. Next on our list is Chairman Farmer.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this bill. I had an amendment drafted here that would take out the A misdemeanor for the conduct of the physician. And what that amendment would say is that a violation of this section by a healthcare professional constitutes professional misconduct. That means that this physician would have to not only violate his professional rules of medical conduct And I think that in this situation that an individual could, even if they lost their healthcare license or if they were charged, say, with an A misdemeanor, I think that the board would still allow them to practice medicine. But I think if we had a situation where there was a direct violation of medical misconduct here, professional conduct, a knowing, blatant violation of medical misconduct, that it would be more likely for the medical board of medical examiners to suspend or revoke a license. Once that license is suspended or revoked, that means the doctor doesn't get paid anymore, which hits his bottom line, right? So I think this amendment makes this bill stronger, and I'm going to move it to ask that we remove that misdemeanor and we put this strong language in place that hits a healthcare professional where it hurts, and that's their ability to practice medicine. So, Mr. Sponsor, with that, I want to ask that we move House Amendment barcoded 4186.
Is there a motion and a second on the amendment?
Motion.
Motion and second on the amendment.
Mr. Chair.
Yes, sir. Go ahead.
And it also says, and it's very clear language, okay? It says, a violation of this section by a healthcare professional constitutes professional misconduct. That means there is misconduct. There's no question, right? And is subject to discipline by the healthcare professional's licensing authority. So that puts them in direct violation. There's no question whether or not they violated it. Now we're up to the point where we're gonna punish this doctor for this misconduct. So I think the remedies of punishment by the licensing authority would be more helpful in guiding a doctor's conduct than a misdemeanor would in this situation. A very rare situation, but I think this is the move we need to make. So I move the motion forward.
Chairman Reagan.
Question on the amendment then, from the standpoint of what's already in the bill. Subparagraph C2 already does that. It says healthcare professionals who violate this section subject to civil action in accordance with applicable healthcare liability provisions, notwithstanding any law to the contrary, a civil action may be filed under this. You're not replacing that, is that correct?
That's correct.
And you're also not replacing subparagraph 3, in addition to any criminal liability under this subsection, a violation of this section by a healthcare professional constitutes professional misconduct and is subject to discipline by the healthcare professional licensing authority? Are you replacing that?
See section 1. And I apologize for that. Thank you, Mr. Chair. May I be? And Chairman Reagan, what this would do, essentially in section C, it would delete C1 and C2, and essentially is your language in C3. It would leave C3 in place.
So you're removing the civil liability protection or cause of action here, is that correct?
I'm removing, it would remove the A misdemeanor, the criminal portion of it, and also would remove the civil, yes, it would remove the civil action and tort. So, yes, to answer your question.
I can accept your amendment for removing the criminal liability, but I think removing the civil action is a bit much here from the intent of the bill. Are you willing to delete that portion of your amendment? I will accept deleting the criminal if you'll leave the other portion in.
If we're able to do that, I would be willing to do that. I don't know. I hate to put the committee in a bad spot, or if we can do so, but it is my intent to just to remove the criminal portion. I've got it. May I make a motion that we submit an oral amendment to amendment? I'd like to make a motion to make an oral amendment to amendment coded 4186 that would only apply to section 1.
Will you hold that motion for
Yes.
just one moment, please?
Mr. Chairman, parliamentary inquiry.
Yes, sir.
I apologize for being late. I had another bill on another committee. Could the chair or legals or update me as to where we are on this bill as amendments and what are proposed before we vote on anything, please?
There is an amendment coded 004186. You should have a copy there in your dashboard. That's what we're on right now. The debate is whether moving a couple sections out of this amendment.
Mr. Chairman? May I be heard on the proposed amendment?
Yeah, Representative, it hasn't, the First Amendment has not been withdrawn yet, but the proposed amendment is in progress. So once we get into that posture, you will be recognized.
Maybe go out of session and ask, may I have a question for legal?
Without objection, we'll go out of session.
Thank you, Mr. Chair. And my question is this, to Chairman Reagan's question about civil liability under Section 2, because my amendment would remove the criminal portion and would remove Section 2. My question to legal is this: by doing this, does this preclude an individual from still moving forward on a civil cause of action under tort?
Michelle Fogarty, Office of Legal Services. I believe it's my understanding that a person could still file an action civilly against a medical professional for tort if they wanted to. Whether or not it would come within the healthcare liability, I'm not sure. I'd have to research that section itself, but I believe someone could still file a civil action at any point if this language was removed, if it was within the statute of limitations.
Chairman Reagan, go ahead for legal.
One of the critical pieces in this subsection or subparagraph 2 we're talking about there is I do put a limit of 7 years after the minor turns 21 years of age. I don't believe that is in existence in any current malpractice tort liabilities. Am I correct on that?
I'm not aware of the current, of what, I don't believe that's in current law. I don't know what the current statute of limitations is on medical malpractice. I'll have to look that up.
Mr. Chair, another question for legal. If the amendment sponsor was simply to make an oral amendment to delete section C1, which is the criminal piece, and leave all else intact, can that be done with an oral amendment, legal?
I would also need to rewrite subdivision C3 because it references subdivision C1. So I would also need to redraft that subdivision to remove the reference to C1.
Mr. Chair, in the interest of time, the sponsor of the bill is willing to accept an agreed-upon amendment that...
I make a motion to go back in session.
Ms. Fogarty, you wish to be recognized before we go back into session?
Yes, sir.
Okay, please do.
It's my understanding the statute of limitations for healthcare liability under 2926-116 is currently 1 year.
Okay, thank you for that. We will go back into session. All right.
Mr. Chairman, if we can get this out of committee, I will agree to accept an amendment between this committee and full committee with the intent of the amendment's proposer that deletes the criminal liability but leaves the civil liability as is and modifies that paragraph to take out the reference, if that's acceptable to the committee. I would point out that I'm being flexible here, but we are short on time because this has already been in the committee twice, and I don't have any more rolls. So if it counters, it goes to the last calendar, which is going to effectively kill the bill because I will not have time to get it through full committee and the other. It's going to be double referred to health committee. So with that with that explanation and my willingness to accept that amendment between committees, I would ask for the committee to pass this out.
Chairman Reagan, are you planning on filing this amendment yourself?
As opposed to a committee amendment?
Correct.
To get this out of this committee, yes, I'll do it.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this important piece of legislation. Members of the committee, this bill is designed to protect children from folks that want to engage in transgender drug therapies and so forth. These are minors. Children don't know everything about the world, and that's why we restrict minors from making certain decisions when they're minors. You learn as you grow, and the older you get, the wiser you get. I think this is important legislation. Why would we want to remove criminal penalties for someone that could potentially damage a young person's life forever, irrevocably? So I oppose the amendment. I'm asking for a roll call vote on the amendment and a roll call vote on the bill, please, Mr. Chairman. Thank you.
Leader Lamberth.
Thank you, Mr. Chairman. And to my colleague, that's a very passionate argument, but I think the amendment has been withdrawn. The bill we would be voted on is as written today. I think the sponsor has said that he's going to work with Chairman Farmer and others on a potential amendment that would be considered in full, but I believe, if I understand the parliamentary procedure that we are in, is that the current amendment would be withdrawn. The sponsor would work with members of the committee between here and full, but we would be voted on the bill as presented. Mr. Chairman, am I correct on that?
Partially. We have not, that has not been, it has not been withdrawn yet, but we're going to recognize Chairman Farmer here.
I'm going to make a motion to withdraw my amendment.
Okay, thank you. Motion has been made to withdraw. All right, thank you. So we're back on House Bill 578, unamended. Any objection to the question? Seeing none, we are now voting on 578 to moving on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. If you wish to be recorded as a no, you may see the clerk. Thank you.
Thank you, Mr. Chair and committee, and I appreciate the discussion.
Okay, members. Let us move ahead here. Item number 33 on your calendar. House Bill 784. Item number 33, House Bill 784. By Chairman Curcio. We have a motion and a second. You are recognized.
Thank you, Mr. Chairman. And is it okay if I present from here, or do you prefer me to go up?
That'll be fine. Thank you.
Okay. Thank you very much, members. We have been discussing in this committee and this committee's predecessors for a number of years the concept of criminal justice reform. Those of us who've been working on this for a long time understand that the importance of separating out who we're mad at versus who we're afraid of. And for a long time in Tennessee, we have gotten those two things a little conflated, I think, at times, through no malintent. But I think as we look forward, we want to find ways to modernize our criminal justice system. We spend now well over $1 billion a year incarcerating Tennesseans. And I would propose, and I have proposed now for many years, that we may not be getting the best return on that investment. And so when we look across the state, we have a 50% recidivism rate. And the question is, what is driving that? Certainly there are bad actors. There are folks who want to be bad boys and girls. And for folks who want to continue to misbehave in those ways, we will always have a hard bed for them in Tennessee. But what we want to see is that for those who are coming out, as we know, 95% of folks who are incarcerated in Tennessee will come out and will become free citizens again. Who they are when they live next door to us or walk alongside us in the grocery store has as much to do with the opportunities and programming that we allow them to avail themselves of while they're incarcerated and as they prepare to reenter, as it does with their own desire, of course, to get better. Tennesseans, I think, loud and clear say we need people to be punished when they do wrong, and I completely agree with that. But Tennesseans also believe that we want to help those who are willing to help themselves. Not everyone can come back from their behavior. There are some folks who we need to put away and put away for a long time. But for many folks who have gotten themselves into a cycle of addiction or may have had a rough start in life but now see the error of their ways and want to move forward, we want to make sure that they have every opportunity availed to them under the law once they have paid their debt to society. So there are two bills before us this morning. One of them dealing with alternatives to incarceration. That's the one I'm talking about now, House Bill 784. Many of us, especially from rural communities like I am, we all have very, very similar stories. We have a family member, an aunt, an uncle, a cousin, a nephew, a niece. We say, you know, so-and-so's a good boy. He's a good girl. She's a good girl. Remember when they were little, went to their birthday parties. Somewhere along the way, they got off track. And I think if they could be given an opportunity to get back on track, they've got good intent in their heart. Maybe we just need to help guide them a little bit. Many of us have seen that, especially with the opioid crisis and the drug scourge that's unfortunately riddled through, especially our rural communities. So House Bill 784 deals with alternatives to incarceration. It does a couple of things briefly. It revises the definition of violent offender for the eligibility of a drug court treatment program. We know that drug courts work. We know that these alternative courts settings have been very successful. Many of us are familiar with veterans courts, safe baby courts, and drug courts, and they are working across the state. So the only thing wrong with them is we need more of them. It requires a defendant to complete a clinical assessment that indicates the need for participation in a recovery and treatment program to be eligible to complete such programming. It also specifies the court has sole discretion where they utilize available sentencing alternatives, requires the Department of Corrections to supervise all sentences to a community-based alternative in incarceration imposed prior to October 1, 2021. And this is something I'm sure we'll have some questions about. The bill in its current form does delete the Tennessee Community Corrections Act of 1985 and all references to community corrections. It also authorizes the Department of Corrections to contract with entities and organizations, including local governments, to create or operate community-based alternatives to incarceration for offenders sentenced to probation, and outlines the contract requirements. So with that, Mr. Chairman, gave you promotion there. I move House Bill 784. I do also have an amendment, by the way, that I filed with the committee.
Correct, and thank you. We were going to address that, if you're ready to do that.
Yes, sir. I'd like to move amendment coded 5039.
Second. We have a motion and a second on that amendment. Would you explain that to us, please, sir?
Yes, sir. Briefly, this adds, and it's fairly lengthy, but it basically adds transition language for moving community correction offenders to TDOC custody.
Okay. Thank you. Any questions for the sponsor on the amendment? Representative Beck.
Let's go back to that last statement about moving community corrections to the TDOC. Why are we doing that?
Thank you, Mr. Chairman, and thank you for the question from my good friend from Nashville. I think as we look across the state, there have been several who have questioned community corrections and the results that they get. I know that's been a topic of much discussion. I have been in the room when those discussions have taken place. I think there have been good points on both sides, and I think those discussions are still ongoing. At the heart of it, we want to make sure that we're attacking that recidivism rate. We want to make sure that that the programming that we're providing is actually being helpful. And so I think there was some that were trying to compare and contrast the recidivism rate for community corrections versus the recidivism rate for the state as a whole. And so that is what bore these discussions. I do know they're ongoing. I anticipate that there will probably be some changes specifically that relate to community corrections. But as the bill stands today, this is the best we've got. I think those conversations are going to continue on even after this morning's committee.
Thank you for that explanation. It doesn't satisfy me. The problem, Judge Wyatt was one of the first to, here in Davidson County, start a drug court, and he has places. drug court is underpinned by community corrections. And their recidivism rate is so low, and they do such an amazing job that it would, I can't understand how I would be able to support this. And it does have a lot of great things, and I commend you for your hard work on this entire bill. But to throw the baby out with the bathwater here is I'm just confused how this amendment to your bill effectively does away with community corrections. Am I correct on that?
Thank you, Mr. Chairman. No, sir, the bill does that. The amendment does not. But just to clarify, no question that drug courts have great success, and that's why we need more of them. Again, those conversations are ongoing, and I think we've even got some witness testimony here today that may speak to the exact question that you have. This is an administration bill. We want to make sure that we get it right, and so again, this is the first of very many hurdles that we need to go through. And so I think you will continue to hear more discussions around community corrections specifically. But if I could have the indulgence of the committee of getting the amendment on the bill so that we've got it in the proper posture. Again, I know there are some folks here to testify that may also speak more to some of the questions that you have.
Okay, I'll defer for the testimony. Thank you.
Leader Lambert.
I know we're on the amendment, and Mr. Chairman, I wanted to thank Chairman Curcio for carrying this bill. We will talk about probably 2 or 3 specific topics within the bill. But when Governor Lee ran for election, this was what he talked about on the campaign trail. And I can tell you, as someone who's been a former prosecutor and now in private practice, just as Chairman Farmer is, I mean, it's needed. We need a full overhaul from top to bottom. This is a large, mission to really do that. And I applaud both the governor and Chairman Curcio in really taking the reins and going at, we have thousands and thousands of people that are sentenced every year, and we're not doing a good enough job. We're not doing a good enough job of making sure that our communities are safe. So this bill, again, we will talk about probably 2 or 3 issues within the bill, but it's a very dense bill that I think will do a whole lot of good within our communities to make sure that while we have a captive audience, I mean, these folks have been convicted of crimes, they've done wrong. If we're going to incarcerate and we're going to put them on probation, which we should, let's use that time well. And so to the point of the community corrections conversation, I mean, Jennifer Woodard is here today, who is the director of our program in Sumner County. I don't think she's going to testify, but I'll recognize her because she does a fantastic job. Those programs, in part, are funded by money from the state, and in large part, because they also supervise those prisoners. So I think the question going forward is how do we make sure to preserve those quality programs and make sure folks like Ms. Woodard can continue to do their job and provide those services. But, I mean, does that mean supervision of these people? And in what way is that funded? Is that through grants or something else? Is that through the supervision fees? Can we do a better job of funding those programs, quite frankly? That's been the conversation for a couple of years, is should we just keep funding it the way we have through supervision fees, or can we do more? And I personally think we can do more. The community corrections program has kind of grown beyond what it initially was set up to do, and that's not a bad thing. But there's also several of these community corrections programs out there that, quite frankly, don't do a very good job. We've got to separate the wheat from the chaff, and we have to do better. This bill, I think, will do that, and I'm glad, again, Chairman Curcio and the governor's office is continuing to listen to learn to much of the testimony we'll hear from today.
Thank you, Leader. Chairman Curcio.
Thank you, Mr. Chairman. And I did just want to clarify because, and I don't think my good friend from Davidson County meant to imply this, but just on the record, this bill does not do a drug courts in any way, shape, or form, and not all drug courts are underpinned by community corrections, though many are. So I just wanted to be clear because drug courts are a phenomenal thing. We've seen them work very, very well. My community, I'm sure, and yours as well. So this would not eliminate drug courts in any way. The other thing that I want to point out, and again, it's a topic of debate. We're continuing the conversation, is that when we talk about transferring these community corrections folks back under TDOC supervision, we are not talking about reincarcerating people who are now in the community. They would still have community programming. They would still be supervised in the community. It would just be under TDOC's purview. Moreover, if the bill became law as it was proposed today, those vendors would be able to contract with TDOC that have a track record of doing good work. under this proposed legislation. Again, I have a good feeling that we're going to continue having the community corrections conversation as we move forward. But I just wanted to be clear, we're not eliminating drug courts in any way, shape, or form. I don't think you meant to imply that, but I just wanted to say that on the record. And we are also not talking about reincarcerating folks or incarcerating folks who are currently supervised in the community. We're simply talking about who administer or who oversees the program. And so it would go from that community corrections model to being supervised by TDOC, but then again, still being able to work with outside vendors when applicable.
Thank you, Chairman Farmer.
Yeah, thank you, Mr. Chairman, and thank you, Chairman Curcio, for bringing this legislation. I just had a couple things I wanted to say to start out with before we get into testimony. Number one is I'm happy to see that our drug courts are doing well. In my district, especially over in Jefferson County, it's doing extraordinarily well. Recidivism rates are down, crime rates are down, overdoses are down, and that's because of the hard work of the judges and all the folks in corrections, maybe community corrections or TDOC, doing the work they do supervising these folks. And the last thing I want to see is something taken away from our judges, from our drug courts, to be able to wrangle these people in, because most of the time, whether we realize it or not, these people are one needle away from death. You know, it's not a matter of if an overdose is going to occur. It's a matter of when an overdose is going to occur. So I want to be sure that our judges and the folks that are supervising these individuals have the tools in their toolbox to properly supervise and to keep the needle out of their arm, neck, toe, wherever they're shooting the drugs into their bodies comes from. And then also, number two, I just want to be sure that we think about the offenders here that would come from corrections to from community corrections to Department of Corrections here. You know, I think a big part of recovery is continuity. And I think within that is I mean, how are we going to, and hopefully we'll hear this from testimony today, but how are we going to take these folks from, you know, the supervision that they have with community corrections over to TDOC? Have we thought through that process? Do we know how these folks are going to respond to that change? You know, they're going through enough change the way it is. So I'm interested. I'm looking forward to testimony today. And maybe even beyond today, looking at the time. But just in statistics, I want some facts. I want to see facts about, you know, apples to apples, you know, from corrections, TDOC, recidivist rates. We talked a lot about that and had a lot of discussion, but I'd like to see some numbers and some facts come out of some testimony. So just giving everybody a heads up is what I'm looking for. And thank you for your indulgence.
Thank you, Representative Hardaway.
Thank you, Mr. Chairman. And I think Chairman Farmer may have cleared up one point for me on the role of the drug courts. I think the sponsor said that this legislation is not doing away with drug courts, but what authority are we taking away from drug courts in terms of contracting with entities to provide programs, community-based alternatives? That's to the sponsor.
Thank you, Mr. Chairman, and thank you for the question. Again, I want to make sure we don't get off base. I don't want to be fast and loose with the facts. That was for a representative from Nashville. This bill in no way does away with drug court. In fact, it expands drug courts. And so there are some drug courts that are underpinned by community corrections. But again, all of the exact same programming would still be available. It's just going to move under TDOC supervision under this bill. TDOC can then still contract with the exact same vendors they do today if they meet the standards, obviously, that we know the citizens of Tennessee expect. So drug courts, actually, we get more of them under this bill. Again, as I said in my opening remarks, the only thing wrong with drug court is we don't have enough of it. So this bill would expand access, and their processes would not change at all. We're just talking about who supervises the community corrections program. Is it something called community corrections, or is it the Tennessee Department of Corrections then working with subcontractors?
Okay, so the contracting with these entities will still be done by the drug courts, but the supervision and the standards are set by TDOT?
Yes, sir, that's correct.
Right. Will there be any any offering from TDOC to say you must use a list in terms of contractors? If this is an approved list, you'll have to select your contractors from this list.
Well, again, I can answer the question this way. TDOC will have the ability to contract with subcontractors, with vendors who are already doing this work now and are doing a job. That may not be the case in every single jurisdiction. Some drug courts may not see a change in vendors. Others may see a change in vendors. So it's hard to, without a specific, on the ground example, what I can say generally is that they'll continue to issue an RFP as they have done since 1985. So nothing about that process will change. It's just who supervises. Is it TDOC or is it something called community corrections?
Okay, then I'm still not clear on that, but I'm going to move to another question. On the accountability, recidivism, will that be the standard?
As far as the accountability for the vendors themselves?
Yes, sir.
Yes, that is the intent, is to make sure that we are getting the best possible results. Again, what's the return on investment for, our Tennessee taxpayers? We want to make sure that we're getting the best possible results.
And will there be transparency where that information is available to the public?
Yes.
And can you tell me where the TDOC is going to take any of the accountability for the recidivism?
Thank you, Mr. Chairman. I know our good friends at the Tennessee Department of Corrections wake up every morning trying to figure out how to solve that problem, and I don't think anything will change after this bill passes.
Okay, Mr. Chairman, I have more questions, but I'll wait and see if the testimony addresses some of those.
Thank you for that.
Thank you to the sponsor.
Representative Griffey.
Thank you very much, Mr. Chairman, and thank you, Chairman Sponsor, for bringing this. With all due respect to the chairman and our good friend from Sumner County, I just respectfully disagree that this is good legislation, particularly as it's getting rid of community corrections, because community corrections oftentimes provides a higher level of supervision. Arguably, while this legislation may not be soft on crime, I think you could characterize it as being softer on crime. It limits the period of probation down to 8 years. It limits probation can only be extended for 1 year. Extends street times for state probation for
Representative
everybody.
Griffey, I'm sorry to interrupt you, but we're on the amendment. We're not on the bill as of right now.
Okay, well, I look forward to the comments from the speakers then, and I'll save my comments for after the amendments are added. Thank you.
Thank you. Leader Lamberth.
Thank you, and Chairman, I'll try not to wander from the amendment as well, but on the amendment, I know it deals with community corrections, it deals with recovery courts. I just want to throw out there for folks to consider. We have asked community corrections and state probation and other probation entities to fund our recovery court programs instead of stepping up as a state and actually funding them. So what they do now is you have local jurisdictions, judges and DAs and public defenders and others that try to get the recovery courts going. And there's not money there for that. Not until this bill and others hopefully will provide those funds, and I hope we provide additional funds. So community corrections and state probation steps up, and they go above and beyond, and they take a very small number of individuals that are interested in recovery court and can benefit from those programs, and they step up and just accept that responsibility. They don't get paid anything else to do it in most instances. There is sometimes some supplemental, but they're just trying to cobble it together. If we want to get serious about recovery court, bills like this, and then putting funds out there from the legislature to establish grants. TDOC has done some of that already, and we can do a lot more. But to try to make recovery court a part of probation, it doesn't work. I mean, it's putting a square peg in a round hole. Recovery court is its own program. It's a totally separate set of programs that, I mean, it's it's even a different mindset from the judge. The judge goes from most defendants seeing that judge as an opponent, as someone who's just trying to lock them up, somebody who's just there to spoil their fun. I mean, because some of these folks consider criminal activity fun. They don't know anything else. That's been their entire social circle until they find that DA, that attorney, that judge that believes in them and says, hey, you can actually do better. You can live life inside the lines in recovery court and learn how to be a productive citizen in society. So I just want to throw it out there. If we want to get serious about recovery courts, then actually put it on the back of community corrections and state probation is not the way to do it. Let's fund it as its own programs like is done in some jurisdiction and actually step up and make that its own program. And again, I truly appreciate community corrections and state probation and all the other probation officers that have taken on this extra load, but most of the time they don't get paid even pennies on the dollar for taking on that extra additional responsibility. So this is a good conversation to have, in my opinion.
Thank you. Any other questions on the amendment?
Just one question, Mr. Chairman. I'll be specific. For-profits like Core Civic, formerly ACA, would they be eligible? They're doing business as private prisons, so, and I would look at it as a conflict. Would they be eligible for being on that list approved by TDOT? That's for the sponsor, Mr. Chairman.
Thank you. So if we're not careful, we can get off on a long conversation about the merits of privatization, and I don't think that's anybody's intent this morning. To the extent that there are for-profit vendors working already in this space, they would still be eligible to fill out an RFP and to bid on business or to submit a proposal for business. But there's nothing in this bill that addresses privatization or for-profit, recovery vendors. Again, all we're doing is we're moving the supervision from something called community corrections to now the Tennessee Department of Corrections. But they can still work with subcontractors and vendors. So the folks that are doing the work now will, in all likelihood, be doing the work tomorrow. It's also, just since you mentioned a specific company by name, I believe that they're actually not in that space, at least not in Tennessee. So I don't think you've got anything to worry about from that standpoint. But again, the folks who are doing the work now will, in all likelihood, do it tomorrow. It's just a matter of who they're submitting their bid to in response to the RFP.
Thank you. Thank you, Mr. Chairman.
Thank you. All right, we are back on Amendment 005039. Any other questions for the sponsor? Seeing none, any objection to the question on the amendment? Seeing none, we're now voting to adopt Amendment 005039. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We adopt. There's also an amendment coded 005297 by Representative Russell.
Thank you, Mr. Chairman. This amendment states that on the fourth revocation, the remainder of the offender's sentence will be reinstated. It's my intent to allow judicial discretion in a future amendment to come in the full committee, though.
Thank you for that explanation. Any questions? I'm sorry, we needed a motion and a second on that amendment.
Second.
All right, thank you. And Chairman Curcio, you recognize.
Thank you, Mr. Chairman. And I just briefly want to clarify for the committee, this is a friendly amendment. This is something that we've had much discussion around, and I know that not only do I welcome it, but the administration it welcomes it as well. So thank you, Representative Russell, for bringing the amendment.
Thank you.
Any other questions for the sponsor, Representative Griffey?
Thank you, Mr. Chairman. For the sponsor, can you explain what your amendment does then, please?
Absolutely. Under the current bill, it says 1 year or the reinstatement of the remainder of the sentence, and this right here just makes it on the fourth revocation, the remainder of the offender's sentence will be reinstated instead of the 1 year.
Any other questions? Seeing none, any objection to the question on the amendment? Seeing none, we're now voting adding amendment number 005297 on the House Bill 784. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We adopt. We'll now roll these two amendments into one. Without objection, we adopt. We're now on House Bill 784 as amended. Chairman Curcio, would you like to proceed, or would you rather us go out of session here to hear testimony?
Thank you, Mr. Chairman. I was just going to say, now that the bill is in the intended format, I think it'd be appropriate to go out of session if it pleases the chair.
Okay, thank you. Without objection, we will go out of session. We have several on our list here today. First up on our list is a David Gray, Sumner County Judge, if he is in the room. He is not. Okay. Zoe Sams from the District Attorney's Office, or a representative of the District Attorney's Conference? They were here. Okay. If you would come up, you can use the podium. You can use this table right here. There's a button there you can push to talk. And please introduce yourself. Let us know for the record your name.
Yes, sir. May I remove my mask?
If you want to, please do.
Thank you. My name's Amy Wyrick. I'm the elected district attorney from Shelby County, and I'm also this year's president of the Tennessee District Attorneys Conference.
Thank you, ma'am. You'll have 4 minutes to begin your comments, and
All
then
right.
we'll have questions.
Thank you so much. We are here as district attorneys, not either in favor of nor opposed to this bill, but merely to point out some issues that we as district attorneys and your state prosecutors have with some of the language. Much has already been discussed in the arena of community corrections, and speaking from Shelby County, they do a great job with our offenders. As it relates to 784, some of the concerns we have is really geared more toward overall issues of ignoring victims, moving farther away from truth in sentencing, and an overall attempt to merely discuss reform and release, or rather to discuss release instead of reform, and that release cannot be the only thing that we focus on when we are looking at reforming our criminal justice system. We have to do more than just release offenders. So tying the hands of prosecutors in terms of limiting probation to 8 years is of concern to us. There are many offenders who we have tried a variety of alternatives with, and sometimes a lengthier probation period is what is needed. Certainly in the state of Tennessee, you have to work hard to actually be incarcerated in prison. Our criminal justice system is geared toward probation. It is geared toward finding an alternative to incarceration. So those offenders that are currently doing time have worked hard to get there. They have committed serious violent offenses, or they have been in and out of the system. They have been on and off probation. Judges and courts, defense attorneys, prosecutors have worked with them to try to find a way to keep them from reoffending. And sometimes the answer to that is a lengthier probation period. I certainly understand, and we as prosecutors understand, that over-punishing people can sometimes do just as much detriment as under-punishment, correct? But that cap on the 8 years would, in some instances, force us to send people to prison that we wouldn't otherwise. So for those offenders that perhaps have pled to 9 years on a sentence, or have some sentences that have run consecutive to one another, our options would be very limited with that cap. Giving people street time while on probation is of concern to us. You could foreseeably, under the way the bill is drafted, have an offender who is not paid any restitution, is continuing to use illegal substances and testing positive, and is not working, not attending school, not doing anything to improve their lot in life. And they would be given the same street credit while out on probation as those offenders who are doing everything we're asking them to do. Those offenders that are going above and beyond and not only satisfying what the judge has ordered them or what the prosecutor has asked them to do, but have gone above and beyond and gotten another job or gotten an additional degree or taken care of other life challenges that they face. So giving that same amount of credit to both categories is of concern to us. And then this idea of only being able to extend the probation to 1 year is going to result in a flurry of warrants being filed and victims being yanked back and forth to court unnecessarily. Sometimes if there are many programs in Shelby County, there are many programs throughout the state. There are not enough, and resources are very slim. And we as prosecutors strive every day to utilize evidence-based, proven methods in our jurisdictions to accomplish what it is we all want to accomplish with every case we touch, and that is to make sure that offender doesn't come back to the system. Thank you.
Thank you. Members, do we have any questions for our?
Mr. Chairman.
I don't know how to stop that. Representative Griffey, I've got you on this first here.
Thank you very much, Mr. Chairman, and thank you very much, General Wire. It's good to see you again.
Yes,
Appreciate all that you do for the citizens of Shelby County and the state of Tennessee. Let me ask you this, General Wyrick. In your opinion or estimate, is this legislation going to be tougher on individuals that come through our criminal justice system, or is it going to be easier on them as far as potential sanctions?
And we're speaking strictly of 784 at this point.
Yes.
I think easier in some regard, given what I've already outlined, the equal amount of street credit for those offenders that are not doing what they're being asked to do, and this inability, this hand-tying of the judges, the inability of a judge to extend probation out to 2 years. It may be that someone owes a very large amount of restitution, and we want to make sure with everything we do, we're honoring victims and trying to make them whole. So that's important to us. It may be that an offender needs to take advantage of services and resources in our community, alcohol, drug treatment. Sometimes the waiting lists for those programs are very lengthy, and an offender may want to avail himself or herself of those programs, but is unable to because there's no room in the program. So hand-tying the judge and limiting their ability to really look at that individual case and determine what's best for not only that offender, but for the community as a whole. Yes.
Thank you for that. Let me, if I may follow up, you're an elected official. You've been reelected to District Attorney General in your district for, I'm not sure how many terms, it's been a number now. Are any of your citizens and constituents indicating to you that the Tennessee criminal justice system is too tough on individuals that come through the criminal justice system? Or what would you be, would you assess it that maybe that more citizens and your constituents are saying that we're too lenient on criminals?
The frustration I hear in the community, the frustration that I see every day in the courtrooms of 201 Poplar is this perceived and actual revolving door of the system. And those of you that know me and have heard me speak know how important truth in sentencing is to me and to the DA's conference. And that is an area that I think while we've done a great job in the last decade, 15, 20 years of enhancing sentences for those that are violent offenders in our community, there is frustration for those property offenders, for those drug offenders, for those individuals who continue to victimize. They're just victimizing in a different way, that we're not doing enough. I'm not necessarily advocating that everybody needs to go to prison. That's not what we're saying at all. We are on the front line of most reforms that are happening at a local level and across the state. But certainly we as a state can and should do more to provide for these individuals so that we can intervene on the path that they are on and keep them from reoffending. So I don't necessarily hear frustration that everybody needs to go to prison, but I do hear frustration that when we do finally get them convicted and sentenced, that revolving door gets to work.
Thank you. And last question. In your assessment, is this legislation as proposed going to make your job, are you and your assistants going to be able to be more effective in addressing recidivism and individuals who violate their probation, parole provisions, or is this going to be offer limited punishment where individuals can recognize they may be able to game the system even more with these changes that are being proposed?
I think it will tie our hands in a certain regard as it relates to offers that we make as prosecutors, and certainly what a judge is able to do once an offender has proven not necessarily, these issues are hard. It is difficult for people on probation to successfully complete probation. I get that. And there are a few moments in my career, 30 years as a prosecutor, that are more rewarding than those offenders who come up to me in the grocery store or wherever it might be and say, thank you for sending me to prison. Thank you for sending me to prison, because that's what got my life turned around. Or thank you for making me go to drug court or veteran, whatever. We do it all day, every day in Shelby County and across the state to find those alternatives. Those offenders that are in prison have proven to us they don't want to take advantage of those options and those opportunities. And so this will limit those options and some of that creativity that we use from time to time, again, for that ultimate goal of doing what we can as prosecutors to make sure that offender never comes back.
Thank you.
Chairman Howe.
Thank you, Mr. Chairman. Thank you for being here, and thank you for coming by my office.
Yes, sir.
We had a good long, in-depth conversation about some things that I think many of us are conflicted over. And in your opening remarks, you made the comment, moving away from truth in sentencing. Could you expand on that?
Yes, sir. Currently, under our state sentencing scheme, it is impossible for a prosecutor to tell a victim exactly how much time an offender is going to do in prison. It's equally impossible for a defense attorney to look his or her client in the eye and say, this is how much time you are going to do behind bars. And that is a constant issue in the offices of the DAs across the state, and it is something that we are working hard to change. As a state, we should be able to tell a victim, this offender is going to do this much time behind bars. They might do more time behind bars if they continue to engage in criminal activity even while imprisoned. But this is the floor. Some of the way this bill is written, not so much as it relates to 784 as it does to 785, it makes it harder for us to tell victims anything. The provision in 785, and I understand we're talking about 784 now, but the provision in 785 for early release for everybody, that adds to the confusion and that adds to the difficulty that we have. And as prosecutors, it concerns us because it seems as if we are moving away from truth in sentencing when the goal of, I know many of you, is to get us closer to truth in sentencing. Yes, sir.
If I may, Mr. Chairman, follow up. Thank you for that response. Truth in sentencing is something that's very important to my constituents. I hear it all the time.
Yes, sir.
I think most of us do. And also a concern about the victims, the rights of the victims. Does 784 or 785, we're not on 785, but does 784 address the notifications of victims? Has anything to do that would create an issue for you?
The extension of probation to only 1 year could cause issues for victims, because what you'd end up doing is yanking victims back and forth to court at a more frequent basis. If a judge is only able to extend a violator's probation out for 1 year, when the judge might have extended that probation out for 2 years and given the victim a little bit of breathing room, given the victim a little bit of time to separate himself or herself from this case, and give that offender real time to comply, real time to make those payments on that restitution, real time to get signed up and attend drug and alcohol training or anger management or life, whatever it is that is on the list that you have been asked to do for this extraordinary relief that you've been given. Yanking them back and forth to court at a more frequent basis within that year would cause some concern as it relates to victims and some frustration. Yes, sir.
Okay, thank
you. And then the street credit piece would cause issues as well.
Yeah. Yes. Well, thank you, Mr. Chairman. In closing, I've had some conversations with the governor. I think most of us have about this proposed legislation, and I agree with the governor. We need reform. I have constituents that are caught in the middle because of a lack of reform. And I've had many conversations with some of those constituents. But at the same time, I want to make sure that we can pass something that I'm not conflicted about, and that we could take care of the victims while trying to help those who are willing to accept help, because some are just not willing to. Some people, you know that as a prosecutor.
Yes, sir.
But there's some that accept it and willingly accept it, and you can help make them into productive, tax-paying citizens. And I think that that's what the goal of this legislation is. But I just want to be resolved in my own mind that that's what we're passing. Thank you, General.
Yes,
Thank you, Mr. Chairman.
Thank you. Chairman Farmer is on our list.
Thank you, Mr. Chairman, and I appreciate you being here today. Just a couple of questions. In your district, do you have any idea about the recidivism rates between Department of Corrections, probation and parole, and community corrections? There's been a lot of talk about that.
I don't have those numbers. I can tell you, and I love to throw this statistic out every chance I get, being from Shelby County. Our recidivism rate in Shelby County is the lowest in the state. Let me say that again for the benefit of my friend Representative Hardaway from home. Our recidivism rate is the lowest in the state. I don't know the difference between community corrections and TDOC. I know that our community corrections in Shelby County works with many more high-risk, higher-level offenders. Those are those cases where a prosecutor might have tried state probation with an offender. We've tried everything, and they continue to reoffend. But there's something about what they're doing, there's something about the case that makes us want to take a chance on them and not just turn our back and say, you know what, we're done, you're going to prison. And so we give them that opportunity to take advantage of community corrections. So they are dealing with a different group, but I don't know those numbers.
Okay.
I can get those for you.
And you led into my next question. You said, higher risk, and I think from the time I started practicing law, when I first started practicing, I took a lot of appointed work. Most lawyers brand new, and I was in the courtroom a lot, and have continued to be, much less since I've been in the state representative, because it takes a little time away doing this, but I love it. But I saw a lot of times my folks I would come in and they would be on state probation, and then the prosecutor would be like, you know what? All right, I'm going to do this. We're going to give them a shot at community corrections. Corrections was almost like the second, well, not second, but the maybe third or fourth choice at first. If things didn't work out, it seemed like community corrections was the last stop until the penitentiary, right? And it always say, well, give them enough rope to hang themselves. We'll extend their probation on out, and if they can't do what they need to do on community corrections, then that's it. They come back, you're probably going to violate them, and they're going to prison, right? Is that what you see as well? I mean, I didn't know if that was just something in my community, because I represent folks in Knox County, Sevier County, Jefferson County, all around that area over there. So
That's typically what we see. We have, a great working relationship with both agencies in Shelby County. But yes, that is my experience, and much like you, it's been a long time since anybody handed me a file, and so to go to court and handle this, and I certainly miss those days. But that was my experience when I was in the courtroom, and that is my understanding of what my 123 plus ADAs are doing on a regular basis in Shelby County.
Right. And one more question, Mr. Chairman. Thank you for your indulgence. And you had mentioned earlier that this may take some options away from your assistance, from your office. Can you go into depth about kind of what do you mean by that? How's that? Can you give us just a couple of examples about real life examples about situations that you've been able to use options with corrections versus Department of Corrections, state probation?
Well, the cap on probation would be one of those. If someone were sentenced or pled to 9 years on a theft of property case, we would not be able to put them on probation because of the 8-year cap. We would have to, the choice would be imprisonment. We have, from time to time, we run sentences wild with one another. We run them consecutive. Somebody might plead to a group of aggravated burglary cases, and for whatever reason, we are looking at probation for that, not being able to give them probation for 12 years or whatever. Those types of cases from time to time are, that settlement is something that is needed. It's what is wanted perhaps by the victim. It's what's best for the offender. And again, My office touches close to 200,000 cases every year. That's everything from speeding to death penalty murder and everything in between. With every one of those cases, all we want to have happen is for that offender to not come back to the system. What settlement can I come up with? What resolution as a prosecutor can I come up with that is going to most accomplish that mission? For a small segment of the population, the violent, the sex offenders, the individuals that continue to victimize citizens in Shelby County, the only option they have left me is to seek imprisonment because they continue to victimize people. But for the majority of the cases that we touch, we're looking for these alternatives. We are looking for an opportunity for this offender to be out, providing for, being a part of a family, a community, but yet holding them accountable for their actions and honoring the victim all at the same time.
One more question, I apologize. And you had mentioned restitution earlier. I know it's a common practice in the courts that I practice law in that an individual is set on a restitution repayment plan that equals the amount of his probation, he or she's probation. Right, so is this going to cause any issues there? I mean, with regards to shortening the probationary period, is this going to cause an issue with repayment of restitution?
For those higher level cases, it could. Yes, sir.
Right.
Yes.
Because our judges will make us put in the plea agreement, a monthly restitution payment that will be paid on or before the probationary sentence expires.
Yes, sir.
So you had mentioned something earlier that if someone owes $10,000 worth of restitution, I mean, is somebody really going to be able to pay, $1,000 a month or $1,500 a month? It's paying court costs and everything else. I have a little concern there, just throwing that out there as well, just seeing that people get paid back for what's been stolen or vandalized from them, so the victims.
Yes, and it's a part of the sentence. In most of the cases, the offender has agreed to pay that restitution back, or the judge has ordered it in their sentencing that they availed themselves of. But I think the other issue that causes us some concern as prosecutors is this inability of the judge to extend the probation period out beyond a year for those very issues. I mean, again, this is real life, and these are hard cases, and sometimes the amount of money owed in restitution is large. And giving that offender the ability and the room to make that money and pay it back to the victim is sometimes is difficult the more you compress that time period within which they have to do it.
Okay. Thank you. Thank you, Mr. Chair.
Thank you for that. Representative Hardaway, you still wish to speak to our witness?
Yes, sir. Your witness happens to be my DA.
Yes, sir.
Thank you, Mr. Chairman. Thank you for being here, General Wyrick. The thing I think I want to emphasize is what I tried to get straight earlier, that we're talking about being able to hold accountable and have transparency in efforts that we can measure in recidivism. And I find it strange that we would try to bring a bigger role for the Tennessee Department of Corrections in dealing with recidivism. In some of my GovOps conversation with the department, the reason that you can't cite recidivism is they don't want you to cite recidivism because those numbers are not readily available. And when it comes to accountability of the programs that TDOC has within their walls, still haven't been able to get those numbers for recidivism. So I have a difficult time in letting TDOC become more immersed in this business when they're not taking care of what's going on now, whether that's their fault or our fault for not properly funding them or making the resources available. And as you held out earlier, Shelby County may not know what it's doing, but is doing it better than everybody else in the state. So we must know something. And if we're going to force conditions on your jurisdiction, then why? If we're already doing a better job than everyone else, okay? And we don't know what the results might be with the tinkering I haven't heard any evidence-based cited reasons for some of these recommendations. You want to respond to that, ma'am?
Well,
You don't have to join on beating up on TDOC. I can do that by myself.
no, sir, no, sir. We know the recidivism rate in Shelby County is better. I've heard that from Commissioner Parker because he loves to stump groups with that trivia question because nobody believes that Shelby County has the lowest recidivism rate in the state. Can we do better? Of course. And must we do better? Yes. Our citizens deserve it. Every citizen, not just the victims of crime. The families of these offenders, the communities where these offenders come from and commit their crimes, everybody deserves us to do better and to do more. But most of that happens with additional resources, again, to your point, being used in ways that are evidence-based, that are proven to have worked. As I said, we have a great working relationship with our DA's office and TDOC in Shelby County as well as Community Corrections. TDOC has completely partnered with us on our focused deterrence, our program that we have in Shelby County for violent criminals. We couldn't do that without the Tennessee Department of Corrections. But it's a program that's been proven to work in other states. It's been evaluated and it's evidence-based. Those are the types of things that perhaps there's a missed opportunity here to grow those types of programs across the state and to make that available beyond Shelby County.
And General Warwick, you're elected.
Yes, sir.
Judges are elected.
Yes, sir.
When something's not going right, you answer directly to the people.
Yes, sir.
TDOC is not elected. Yes, and with that having been said, Mr. Chairman, I've got more, but I'll save it.
Thank you
Thank you for being here, General.
Thank you.
Chairman Curcio.
Thank you, Mr. Chairman, and thank you, Ms. Warwick, for being here, and appreciate you sharing some things with us. I think and this is kind of my overall political philosophy, but I think it's especially true today, is that we both agree on where we want to get to. We're just arguing over the details, basically. So, I agree that the biggest bit of feedback that I think we all hear is this revolving door scenario, which is exactly why we think the system needs. So I wholeheartedly agree. I think what this bill seeks to do is to bring the rest of Tennessee, poorer counties like the ones that I hail from, up to the same standard that Shelby County is able to afford through its own largesse. So there's no, the special sauce to Shelby County's success, I wholeheartedly believe, is that you all have some of the most criminal justice reform-minded policies already anywhere in the state of Tennessee. So a lot of the things in this bill sort of brings, again, poorer counties without those resources up to speed to where Shelby really is today. So I know we'll have a lot of discussion moving forward, but and I think there's some folks here from the administration as well to talk about it. But again, I want to reiterate that we agree we all need a safer Tennessee. We all want to attack that recidivism rate. 50% is unacceptable. And to your credit, in Shelby County, you're at more like 30%. Where I was in Knox County last weekend, it's at 75. So we've got to do better. I know we both agree on that, and the details of how we get to that endpoint, I think, are just what's for debate here today. So thank you for highlighting the work that Shelby County is doing, because again, in my view, what this bill does is it brings some of the poorer counties up to that standard that Shelby is able to afford. So that's what we're attempting to do today. Thank you, Mr. Chair.
Thank you, Representative Beck.
Thank you, and thank you, General, for your testimony today. I've really enjoyed it. Most of the questions I was going to ask, you've already covered, but a couple that you've raised with me are, you mentioned the 8-year cap on the sentence of parole. What is the cap right now?
It's currently 10 years. Unless for a split confinement sentence. But you can put somebody on probation for longer than that if it's straight probation and you're running sentences wild. If you're, again, with these higher level theft cases, or if you've got a series of aggravated burglary cases and you're running those wild, running those consecutive. Yes.
Very good. And thank you, Mr. Chairman. And the community corrections, how would this bill affect your ability to use community corrections in your courts, in your system?
If community corrections were eliminated,
If, under this bill, how would it affect your ability to deal with community corrections?
well, I think it would take away that independent agency that we rely on for some of these more high risk. Again, to Representative Farmer's point, the individuals that we have tried everything that there is in the toolbox to use for these offenders, and we are trying community corrections as a last resort. Those are some of the immediate examples that come to mind. But they are an independent group that we utilize, and they are run very well from Ms. McAllister and Ms. Matthews in Shelby County.
Very good. Thank you very much. And, Mr. Chairman, I've got a constituent I meant to recognize earlier. Larissa Burdette, we're glad to have you here today. Thank you so much.
Thank you. Any other questions for our guest, Leader Lamberth?
Thank you, Chairman. And General, I just want to thank you. You do a phenomenal job for your community. I hope they realize just how much you put into it and your staff does. I did want to make kind of one point on your testimony. You'd mentioned the street time. I know in community corrections, you get automatic street time. You're guaranteed it. Under this bill, it would give discretion to the judge, and your staff could argue that someone did not deserve the street time. So it merely gives the option out there. Is that fair enough?
Fair enough. But
Okay.
it equally to those that are doing everything they're supposed to do with those offenders who have continued to utilize drugs, who are not reporting, who've picked up B and C misdemeanors and those types of things. Yes.
Sure.
Yes.
Chairman, if I can go back and forth a little bit, I'm going to try to speed it through. I just wanted to highlight that because, I mean, it does, I like that, option as a former prosecutor. I mean, there were times when somebody had a lengthy sentence, they'd done well for several years and then messed up. I mean, putting the sentence into effect didn't seem to be the thing to do, but a year was the max that we could really, do in court. I mean, on a probation violation, judge could give them 365 days, day for day, but it was either that or put the sentence into effect. And so this seemed to give some greater options there on some of that. There are some other bills here that also deal with some of the restitution issues. It should be much easier to turn that into a civil judgment than it is currently. I've always been a little uncomfortable within the system, saying, well, look, we're going to extend your probation or put you in prison because you weren't able to pay the restitution. Now, if somebody purposefully didn't pay it, that's totally understandable. But if somebody is unable to pay a large restitution amount, extending their sentence out, I'm not comfortable with. I don't think that's what you were recommending, but it does get into this quasi collections on a civil judgment, and we have a victim that needs to be made whole, but not every defendant that has committed those type of property crimes can do so. And so this seeks, I think, to remedy some of that, and I hope that would work out in the sentencing process when you're looking at each case. That, I mean, hopefully it'd be much easier to get a civil judgment, and again, it wouldn't just be about, well, if they're not on probation, the victim's never going to be made whole. Any thoughts on that?
Well, I think restitution is one of the elements that a probationer may have to comply with for their term of release. There are multitude other objectives that a judge may set or an ADA may request in that disposition. And so if you have to continuously file these petition to revoke warrants and bring that offender back and forth to court at a more rapid pace, that also means you're yanking that victim back and forth to court at a more frequent rate because we know that clock is ticking on that 1 year cap. And instead of giving us a little, and again, it's a resource issue. It's a volume issue because of the great number of cases that we have statewide as prosecutors and certainly in Shelby.
And General, I know we're basically out of time here in just a moment, so I'm going to, just the last point I'm going to say is I share your zeal, and you know this. It's time to redo the entire sentencing code.
Yes,
I mean,
sir.
it's time for truth in sentencing. It's time that, when you get a sentence in court and you've exercised all these other options that I know you want to try, and it's time to say, look, we got no other option. You got to go to prison. That offender, the victim, the probation officer, if there is one involved, the DA, the judge, everybody should know this is how much you're going to serve. And I love what you said. And if they misbehave in prison, if they don't do the programs, then fine, extend the sentence. But don't cut their time down and make victims go beg to keep somebody in prison that shouldn't be getting out anyways. So thank you for working on that. I know that's a different bill, but it's way past time for us to work on that issue. Thank you, General.
Yes, sir.
Thank you, members. Thank you, General, for being here today, for your testimony and willing to stand here and take questions and give your thoughts. Here in just a few minutes, I'm going to, well, now I'm going to go ahead and make an announcement, and then here in a few minutes, we're going to recess. We're going to come back at 5 o'clock this evening, 5 o'clock to take up the remaining portion of this piece of legislation, as well as item number 34, House Bill 785. Those that are on our list that were set to testify today that are here, you're more than welcome to come back at 5 p.m. to be heard on these two bills. So I just want to make sure that's out there. So we're going to go back in session. We're back in session, and we, committee will stand. Representative Hardaway, real quick.
Thank you, Mr. Chairman. Are we only going to hear these two bills tonight?
Yes, sir. When we come back, these will be the two that we take up tonight. But we will we'll go out of session, or excuse me, recess until 5 p.m. Thank you.